And if what Jeff has advised you to put in your agreements hasn't solved your problem, and if Ben's non-judicial options haven't solved your problems, you end up talking to somebody like me. I am a commercial litigator here at the Dickinson Law Firm. I do collateral enforcement actions, foreclosures, as well as some practice in bankruptcy. Have some experience in Chapter 12 bankruptcy as well, which is particularly relevant here. I want to talk about an issue that I've seen crop up several times when dealing with distressed agricultural borrowers, and that is a distressed borrower comes in and says, I know my operation hasn't been cash flowing, and I've got concerns about my profitability coming forward or going forward here, so I know what I'm going to do. I'm going to switch to organic farming. And the reason I'm going to do that is because I'm going to pretty much double my price for grain. I've given you kind of a summary here of the recent price of conventional commodities such as corn and soybeans compared to some organic prices, and you can see that they're almost twice as much in some cases, if not more, than what the conventional crop is worth. And so a lot of producers will look at that and say, well, here's the answer. I'll just switch my operation over to organic, and that'll solve all of my cash flow problems. And we'll be on easy street from here on out. May not surprise you to learn that it is not quite that easy. In 2002, the USDA came out with a comprehensive set of regulations that spell out what is necessary in order for your operation to be able to sell certified organic commodities. And certified organic is where the money's at, because that's what allows the people that purchase those commodities to then turn around and market their products as being certified organic as well. The USDA has kind of set out a 5-step process that you can find on their website, and I've just kind of grabbed it and put it on this slide. It's simple to write, terribly complicated in its execution. There are a number of requirements that have to be followed, probably the most significant of which is the operation has to be certified by a certified organic certifying agent. And there's a number of entities that are qualified in and around the state of Iowa to do that. But this isn't just some rubber stamp kind of operation. These certifiers have to come out and work closely with the producer to ensure that they successfully shift their operation over to organic. One of the other problems, or challenges I should say, with switching to an organic operation is that even though your prices may increase substantially, your yield is going to go down. There's research from the USDA that shows about a 25% reduction in total commodity yields across all or across 3 of the major commodities there. Obviously, that'll vary by producer and by operation. I've certainly seen evidence presented of situations where organic operations were able to achieve yields much closer to what you would get from a conventional operation. But that's not going to be true for everybody, and it depends a lot on the operator and also on the characteristics of their operation. And to be honest, the initial yields are probably going to be a lot lower in the first couple of years after an organic switch as the operator fine-tunes their organic operation. There are a number of compliance issues that I think producers may not be aware of when they first come across the idea of switching their operation to organic. The first and most significant, of course, is that they have to let their ground lay fallow for 3 years. I say fallow, it doesn't really have to be fallow. There could be alternatives, alternative crops grown in that interim period. But what they cannot do is grow conventional crops on the ground that they plan to use for organic crops, because the ground has to be free of prohibited substances, which means it has to be free of all of your standard herbicides, pesticides, fertilizer, and as well as GMO seeds. USDA has some recommendations for what the operators should do to try to cash flow during that interim period. They could certainly plant organic qualifying crops and treat the operation as organic during that 3-year period, but they're not going to be able to get that organic certification. So they're only going to be able to sell their crops for conventional prices. And as you already saw, the yields during that time period are going to be lower, so it may compound cash flow problems that they're already experiencing. One of the things the USDA emphasizes when operators are looking to transition their operation is they have to kind of rethink their approach to farming. A lot of operators approach organic farming with an input substitution mindset, where they think that they can just go to the list of approved herbicide products and pesticide products and just substitute one of the approved products for the product that they typically use, and then substitute compliant seeds with the GMO seeds that they typically plant. And USDA guidance is very clear that that's probably not going to work. Instead, the operator has to combine cultural, biological, and mechanical practices to try to achieve the same results that they are currently getting with modern fertilizers, herbicides, and pesticides. One of the more vexing problems for a lot of these operations is figuring out what to do about pests, including insects as well as invasive weeds. A lot of the products that are permitted to be sprayed don't have the same impact as a conventional pesticide or herbicide, and so they're going to have to combine a number of practices, including planting other crops that are designed to attract insect predators in amongst their existing operation or their existing crops. But of course, then that's going to add competition to the organic crops, which will then decrease their ability to grow and produce a yield. So from my experience in litigating organic transition plans in bankruptcy, one of the points that all the experts have made is that it takes an operator a couple of years to really fine-tune that operation into one that's achieving yields that are sort of the best possible while remaining consistent with organic practices. One of the things that I think surprises many operators is that not all manure is equal. There are actually strict limits on manure fertilizer in the organic certification regulations. And generally speaking, manure can come from animals that have been fed conventional crops. And so just because livestock are consuming conventional corn does not mean that the operator is prohibited from using that manure on the field. However, there are certain sources of manure that may contain levels of pesticides or other prohibited substances that exceed the limits in the organic regulations. And so the certifying entity that actually comes and certifies the operation may want to identify that manure source and actually test the manure to make sure that it complies with the USDA regulations. Again, a lot of what I've seen when I was litigating one of these cases recently is the operator gets up on the witness stand and I'm cross-examining him, and he makes a statement, well, all manure is manure, and I don't need to have a plan as to where my manure is going to come from because we'll just get it from my my hog house here on the property. And while it is entirely possible that manure would be sufficient and would comply, nevertheless, it would probably need to be tested, and there was no way that operator could tell me sitting on the witness stand right then that his manure was going to be compliant with USDA regulations. There's also limitations on how soon or how proximate to harvest you can apply your fertilizer unless you engage in some kind of composting. As I mentioned, GMO seeds are also prohibited. One of the challenges that an operator has during the transition period is ensuring that they have put together an organic system plan that identifies all the ways in which they're going to ensure their operation complies with the organic regulations. One of the issues in that organic system plan will be identifying a source for their seeds. to ensure that they have the appropriate characteristics, but to also ensure they don't have any banned substances, such as any substance applied to the outer coating of the seed that's designed to reduce fungus or some other kind of desirable coating. Conventional seeds can be used, again, as long as they're not GMO. One of the problems that an operator might face is if they're only transitioning part of their operation to organic, so they'll have part conventional, part organic, is making sure that they don't accidentally cross-contaminate the organic section of their operation with conventional seeds. So that means cleaning out the planter before they go and plant their organic seeds, or planting organic first and then doing conventional after the fact. The regulations also make clear that the operator needs to pay attention to waterways that might flow through an organic field from a conventional field. Those waterways obviously can transport banned and prohibited substances, which could cause the operator to lose that organic certification. And of course, if that happens, then that operator is going to lose all of the benefits that come with an organic certification, namely the price boost that they see. Some of the other issues that you may want to keep in mind when you're talking to an operator about who's considering switching to organic, particularly a distressed operator, is that if there are other creditors that have an interest in that particular operation, they're going to closely scrutinize a new venture like switching to organic farming. And there's actually some law up in the Northern District of Iowa, bankruptcy court, which is just about everything north of Interstate 80, where the bankruptcy court up there took a close look at a debtor's proposal to significantly and substantially change their operation. The case was called Plymouth Oil, and it didn't involve a farm. It involved a food processing company, but the lessons from that case are very instructive for a situation where you've got a farmer who's looking to change to organic farming. What the bankruptcy judge up in the Northern District said is a operation's past performance is the best evidence we have of what their future performance is likely to be. And particularly in bankruptcy, if a farmer files a Chapter 12 bankruptcy where they're looking to reorganize their operation and then come out of bankruptcy and continue to operate, the court is looking for what will be different. If a farmer goes into Chapter 12 and essentially says, look, I don't really need to change my operation, I'm just going to keep going the way I've been going, bankruptcy court is going to say, no, I'm sorry, your past performance does not indicate that that's going to work for you. But at the same time, if the farmer comes into Chapter 12 and says, look, it hasn't been working using conventional crops, but I'm going to switch to organic and then it's all going to work, the court's going to look closely at the past performance and say, well, why do you think after failing at conventional farming, you're going to be able to make that switch to organic? And particularly where there's no track record of doing any kind of organic farming, the court is less likely to approve a plan where farmers are going to change their operation over to organic. And what is more likely is the court is either going to dismiss the bankruptcy or switch it over into a Chapter 7 liquidation. And I mentioned other creditors a few minutes ago because you as a primary lender may decide after looking closely at the operation that you think this particular operator can do it. They've had some unique situations that cause them to experience extreme cash flow difficulty, but you think that those can be explained and that you're ready to partner with this operator and take the risk on a transition to an organic operation. Other creditors may not be willing to do so, particularly junior creditors who may have junior liens on the land. They may come into a bankruptcy where you and the operator have said, Judge, please approve this plan for reorganization. We really think that this is going to work, so let us out of bankruptcy and we're going to make a go of this. Those junior creditors have the ability to step in and put a halt to that. And what they're going to rely upon is the case that I'm talking about right here, which is the case that says if you're going to substantially change the nature of the operation into a business that particular debtor has no background or experience in, we're really going to scrutinize that as a court and be less likely to approve of that plan than some others that the debtor may have background or experience in. So when it comes to organic farming, it's important to keep in mind that you really need to get involved with the operation. I've seen the bankruptcy cases I've handled, and every bankruptcy case I've handled involving a farmer has involved the farmer coming to the court and saying, I'm going to switch to organic farming. You need to closely scrutinize that plan, because in every case that I've encountered, the operator hasn't really looked at it very closely as far as what is required, and instead has been fixated on the price difference that they're going to enjoy if they're able to get that organic certification. So if you're in the stage of negotiating a forbearance agreement or some other kind of loan modification agreement, and the reason you're doing that is because you think the operator is going to be able to change to organic, you need to have a hard conversation with the operator. And as Ben suggested, you may want to include a number of those requirements for the organic certification in your loan documentation, so you can ensure that if the operator doesn't meet those requirements, that you have the ability to proceed then to enforce your rights against the collateral. So thank you very much. If you have any questions about bankruptcy, foreclosure, any of the loan document modification issues we've talked about, please feel free to email Ben, Jeff, or me, and we'll be happy to get back to you.
All right. That concludes our webinar. Thanks, everybody, for attending, and thanks to Jeff and John and Ben for this great information. We do have some questions, but since it is 1 o'clock and we're up against a time limit, we will be answering those. We'll be sending out answers here shortly this afternoon. And with that, unless, Ben, do you want to answer this question right now, or?
Well, I can take a stab at it.
Yeah.
So essentially, upon a divorce, that divorce, whether it's a stipulated settlement or an order by the court, they can transfer